Oftentimes, when we look at a case to determine if it falls or qualifies for a lemon law case, the issue needs to be so severe that essentially you cannot drive the vehicle. It really needs to be an unusable vehicle. So, for example, you're driving on the highway and your vehicle shuts down while you're mid-driving. That is so severe that you cannot use that vehicle and you need to pull off the road immediately.
Welcome back to Lemon Law Unpeeled, the Lemon Law podcast. I'm Emma.
And I'm Courtney.
And I'm Steven.
Today's episode is going to be talking about the difference between lemon law and breach of warranty claims. This is a common area of confusion for a lot of clients, thinking that lemon law and breach of warranty are one and the same, but each state actually has two separate laws that deal with these types of claims. And Courtney, I'm going to let you lead off with talking about what's the main difference between lemon law and breach of warranty, between, not state specific, but just generally, what's the difference between the two of them?
I would say, Emma, the biggest difference is for lemon law, the issue has to appear earlier. Every state is a little bit different, but let's take Pennsylvania, for instance. The issue has to start within the first year or 12,000 miles, whichever comes first. And every state's a little bit different, but usually somewhere in between there, between 1 and 2 years and 12 to 24,000 miles, the issue has to present itself. Whereas breach of warranty, the issue can present itself at any point during the manufacturer's warranty period, which every manufacturer is a little bit different, but typically 3 years, 36,000 miles, sometimes 4 years, 50,000 miles. So for lemon law, the issue has to start earlier and it has to be severe. It has to be egregious. It has to be something that is literally preventing that vehicle from being driven from point A to point B. Whereas breach of warranty, the issue can be anything. It can be big, it can be small, it can be a temperature sensor, a radio. And lastly, I think the biggest difference is under lemon law, the issue has to be ongoing. It can't have been repaired. Under breach of warranty, we can recover even for a fully repaired defect. So I think it boils down to those three things. Lemon law, it has to start early, it has to be severe, and it has to be ongoing.
Right. And Steven, I'll let you talk about the damages are different too, right? So each law will specifically state, hey, if I'm violated or if this law is violated, then these are your damages or these are what, you can be awarded from the defendant. So I'll have you talk about the difference between the two when it comes to what the ultimate recovery is going to be.
Sure. A state's lemon law is a law that provides compensation to a consumer when a vehicle repeatedly fails to meet the standards of quality and performance, whereas a breach of warranty claim is an option when the vehicle does not qualify for a state's lemon law. While a state's lemon law has very specific requirements and outcomes, a breach of warranty claim is broader, so this does affect what you are able to seek under each different claim. For a state's lemon law claim, it clearly states that you can seek either a repurchase or what is also known as a buyback of the vehicle, or a replacement of the vehicle. That's where the manufacturer does what is known as a collateral swap, and you would get a new vehicle to compensate you for your defective vehicle. A breach of warranty claim is not as specific. It is actually more of a broader law that we often rely on when a vehicle does not qualify for a state's lemon law. Normally in this situation, because the law is not clear on what a consumer is entitled to, normally we are seeking the damages through a cash resolution, and that is normally the difference on what you bought and what you have in as a result of your issues.
The main difference in damages, right, between the two is that under lemon law, your vehicle needs to be repurchased or replaced, right? You either give it back and get your purchase price back, or you swap it out for another vehicle of equal or greater MSRP. Whereas for breach of warranty, we're generally looking at what we call a cash and keep. So you get cash from the manufacturer, but you keep your vehicle. You still have all your warranties. You still have all the rights and remedies that you would normally have with this vehicle, with the exception of you can't bring a second breach of warranty claim on the same car, right? It generally is a one and done type of situation. And that's what kind of differentiates the two, is that we cannot get a buyback under breach of warranty. Mainly, that is just a lemon law remedy, whereas for breach of warranty, you're just looking at cash. Courtney, when a client is, listening to this or trying to consider their options, what would you say is the most important focal point for them in terms of when should they start seeking legal help, right? Do they need to really be concerned about the particulars of lemon law, or what really should be at top of their mind when determining, hey, there might be something going on here that I should call for help?
Yeah, once you find yourself back at the dealership 3 times for the same problem, or your vehicle's been out of service about 20 days for the same problem, give us a call. That's usually when we can start a claim. Again, every state's a little bit different. Sometimes it's 20 days, sometimes it's 30 days, but absolutely give us a call or start thinking about lemon law or breach of warranty when it's been 20 days out of service or back 3 times for the same problem.
As a consumer, I would mainly just be concerned in terms of what your state's lemon law says in terms of the timing, right? Because you don't want to have your problem start within the requisite time period, but you delay in bringing it back for one reason or another, and then you miss that window. Because lemon law generally does require that you have your multiple visits within a specific time frame, where breach of warranty just requires that the problem start while you're still under the original factory warranty. So I think the best rule of thumb, right, is when you start experiencing problems with your vehicle, just generally don't hesitate, bring it into the dealer. And then if you are continuing to deal with that problem, like Courtney said, multiple times, or it's been out of service for a while, that's when you really want to start maybe calling in to your state's attorney general's office or calling into lemon law firms to see, hey, is there something going on here that I'm going to need help with? Steve, I'm going to let you talk about what sort of defects do we generally see for lemon law, right? So we talked about how lemon law has to mainly be a severe problem, but what would you say the court considers to be severe?
So oftentimes when we look at a case to determine if it falls or qualifies for a lemon law case, the issue needs to be so severe that essentially you cannot drive the vehicle. It really needs to be a unusable vehicle. So for example, you're driving on the highway and your vehicle shuts down while you're mid-driving. That is so severe that you cannot use that vehicle and you need to pull off the road immediately. Another example is smoke coming into the cabin or compartment of your vehicle, whereas it's not breathable. You have burning fuels going on, maybe oil's burning, something where it makes it unsafe for you to be in that vehicle. So it has to be so significant where we like to say, can you drive it safely or do you need to pull it off and should that not be used? Those are the type of issues that we look at when we are considering whether or not it falls or is eligible for a lemon law claim.
Right. So usually when somebody calls in and reports, hey, I'm having issues with my navigation, my Bluetooth, or things like that, usually that kind of indicates to us that, hey, most likely this is going to fall in the breach of warranty camp as opposed to lemon law because it is a defect that has to be one that's considered substantial. And Courtney, something that you and I have experienced that clients do tend to kind of focus on is each lemon law has different requirements for substantial, right? So for example, PA says it has to substantially impair use, value, or safety. Maryland says it has to substantially impair the use or value. But as a practical matter, I'll let you talk about, kind of what the court really means by that and the difference between the way the law is written and then the way it can actually be practiced.
Yeah, absolutely. So a lot of times a client will say, well, this is absolutely substantially impairing my use or value. My radio doesn't work at all. I wouldn't have bought this car if I had known that. That's absolutely substantial in my mind. But unfortunately, that isn't the standard. It isn't a subjective standard. What the courts have really fleshed that standard out to mean, in Pennsylvania at least, is that the vehicle is completely useless, completely valueless, or so dangerous that it is essentially, and I quote from a case, a death trap on wheels. So it can't be something that, yeah, maybe you wouldn't have bought the vehicle had you known about this problem. You consider this to be very important. It has to truly be preventing you from driving the vehicle, making the vehicle such that no one else would ever want to purchase this vehicle, and truly dangerous.
Right. Because we have a lot, and Stephen, you and I can talk about the case that we had recently. It was a Dodge Ram, but it was a vehicle that only a certain number of them were issued, right? So it actually was a classic vehicle, I guess you would call it, or a specialized vehicle where if parts are replaced, it loses value faster than, say, your run-of-the-mill type vehicle, right? There was only about, I think, 100 of them sold. They're very expensive. And if he were to go to resell it, the VIN, on the engine wouldn't match the actual VIN on the car. And a major issue was that, well, that substantially impairs the value of the vehicle because this isn't just, your normal Dodge Ram. This is something that was specially made. They don't make them anymore and is a classic item. How can I recover for that? And I'll let you talk about how, unfortunately, that's just not a consideration.
Sure. So when that type of situation arises, while it does affect the originality of the vehicle, it does not impair your ability to use the vehicle. So in that situation, when we evaluate the case, we are looking more at a breach of warranty claim. That is where we look at how we try to get you compensated for the issues that you've had with the vehicle based on what is going on. So in that situation, we look at what is the difference in what he paid for and what an expert would likely testify is the valuation of his vehicle based on the defects and issues he's had with the vehicle. In that situation, we try to get the client as close as possible to the difference in value of the vehicle, but we cannot always guarantee it's going to be exactly the same amount. But the purpose of the breach of warranty claim is to try to get you as close as possible to where you were had you not bought the vehicle, but it does not guarantee that you'll absolutely be 100% back to zero.
Right. The law isn't as nuanced that it takes into account, but if you have this type of vehicle or a limited manufacturer, you get more damages. Unfortunately, the law just looks at the defect and how it impedes the ability of the car to function. Similarly, so when it comes to breach of warranty, where you get a percentage of your, purchase price back to compensate you for the loss in value, just because you have a more expensive vehicle doesn't mean you're going to get more money. So the best example I can use is, let's say a client comes through the door and they have a Kia Sorento, right? And they're having Bluetooth issues. And then we have another client come through the door that has a Range Rover that's also having Bluetooth issues. Just because the Range Rover was a $100,000 vehicle and the Kia Sorento is only a $35,000 vehicle does not automatically mean that the Range Rover is going to get more money, right? The law doesn't make those differentiations. It just mainly looks at how severe is your defect, how much is it impeding the value of the vehicle, and that's your compensation that you get back. It is a sliding scale in terms of severity, but the scale does not slide in terms of price point for the vehicle. Courtney, I'm going to let you discuss, when it comes to lemon law or breach of warranty claims, how the process can differ a little bit in terms of notice to the manufacturer, right? And how each state would handle notice for a lemon law claim versus a breach of warranty claim.
Yeah, so states can be a little bit finicky with a lemon law claim. Some require that you give notice to them and a final opportunity to repair. So in other words, you send a letter saying, hey, this is the problem I'm having. It's been back multiple times. And then you need to give them 10 or 15 days notice and allow them one more chance to repair the vehicle. Sometimes that letter has to be sent via certified mail, return receipt requested. So it can be a little bit finicky, and sometimes there's some hurdles to jump through there. Whereas for breach of warranty, most states, with the exception of maybe one or two that I can think of offhand, will not have any such requirement. You can just jump right ahead to filing that legal claim.
Right. So every state does handle it a little differently, like you said, Courtney. New Jersey, it's not required that you send the final repair attempt notice, but it's strongly encouraged. Pennsylvania, you can just go right ahead and file. You don't have to give any notice. And then there's states like Georgia, for example, which I'll let Stephen talk about, which is very strict. They have a step-by-step instructions that you have to follow in order to even get to the Attorney General's office for them to set you up with an arbitration date. So I'll let Steve just briefly talk about those steps.
Yeah, so in Georgia, they are very stringent on making sure that you meet every requirement before you can even pursue it before the Attorney General's office, as Emma just said. First, you need to send a notice for a final repair attempt. The manufacturer must have that opportunity, and so if they are able to successfully repair the vehicle at the final repair attempt, your case is done. That's where it ends because they were able to properly repair the vehicle. If they are not able to repair the vehicle at the final repair attempt, you send them a 20-day notice where they have the opportunity to repurchase or replace the vehicle. Should they disagree and not honor that request, then you need to file with the Attorney General's office. However, if you try to file before doing either of these steps, the Attorney General's office will say, no, you're not ready. Your case is not able to be brought before us.
Right. And what's tricky, too, is that final repair attempt notice, you got to send it within your lemon law period, right? That 2 years, 24,000 miles, because you have to notify the manufacturer of your potential lemon law claim and give them the opportunity to cure it within that period before you can move forward. So it's really important that you follow those step-by-step instructions when it comes to lemon law when pursuing your claim. And a lot of other states have similar requirements too. right? Like Maine, for example, if you want to be able to file a case in civil court, you have to have gone through either the state arbitration panel first or through NCDS or the BBB in order to be able to take it to that next step. And you have to do that before the vehicle hits 3 years old or 18,000 miles. It can be very nuanced, and that's why it is important, especially with a lemon law claim, to have an attorney assist you with those cases when moving forward. So that's why it's so important to have an attorney guide you, especially when you have a lemon law claim, because it's really important that you hit all the marks to prevent you from running into any issues down the road and having your lemon law claim kicked out because you didn't follow some certain rules that they have. Now, Courtney, I'm going to let you talk about in the event that the manufacturer does agree to repurchase a vehicle, what does that look like for the consumer? What do they get back? How is that calculated? Because and I'll let you talk about this, but often, right, we have clients saying, well, once we get their calculation, can we send a counter? Can we negotiate with them? And so I'll let you explain why that we can't really negotiate with them. All we can really do is make sure that they're following the terms of the law.
Right, exactly. So if you're getting a cash and keep offer under breach of warranty, that's a negotiable offer. That's something that will make a counter demand. They'll make a counter offer and we go back and forth. Lemon law, however, if you're getting a repurchase under your state's lemon law, that number is not negotiable. And I do have this conversation with clients all the time as well. It goes according to the state's lemon law statute, and every state has a formula laid out in their statute. So as long as they are following that formula, and that's what we'll make sure they're doing, there's nothing to negotiate there. So theoretically, what you get back is your down payment and your monthly payments. The vehicle is taken back from you and your loan is paid off. So it's like returning something, returning a product to a store. However, it's not quite that simple, and you're not going to get back every single dollar. There are some deductions. A lot of states have a mileage deduction, which is sometimes kind of a convoluted formula. A lot of states have a mileage deduction, which can be a confusing formula. In most states, it's something similar to the mileage at which the problem started, multiplied by the purchase price, all divided by 100,000. Pennsylvania's is simpler. It's 10 cents a mile up until the problem started. So that number can become high. You could end up with a really high mileage offset depending upon when the problem started. There are also other deductions that can be taken, extended warranties, service contracts. That's an amount of money that was not paid to the manufacturer, but was paid to a third-party vendor. So that amount is going to be deducted. However, you will get that back from the dealership. You just go to them, explain the vehicle is being back, and they will prorate and refund the majority of that money. If you had any negative equity, that can be a kicker, and that can sometimes make these deals fall apart. For instance, when you purchased your vehicle, if you had, let's say, $15,000 on a loan from your previous vehicle that you traded in, and you're now rolling that $15,000 loan into the loan of your new vehicle, that's negative equity. So when your vehicle is being repurchased, the manufacturer isn't going to pay that $15,000 loan as well. So that's money that's going to be subtracted. So I have actually had clients who owe money in order to get the vehicle repurchased under the Lemon Law because their negative equity and any other deductions are actually greater than the amount of payments that they have made thus far. So in that situation, sometimes someone will see the numbers and say, you know what, back up. Let's actually go back to the cash and keep offer. I'll take the money and I'll keep the vehicle, or I'll take the money and I'll try to trade out of it on my own, because these deductions really can add up.
Right. Because as I sort of explain it to clients, the manufacturer is simply responsible for the purchase price of your actual vehicle. So if the amount that you financed is greater than that, it puts you upside down. And negative equity can be really tricky to spot. These dealerships, I feel like, are very clever in how they word it when you're there purchasing the vehicle in terms of rolling it into the loan, because we do often have clients that don't seem to quite understand that. And when you look on the purchase agreement, the way that they set it up, and Courtney, you and I ran into this issue recently where even we were looking at it, kind of scratching our heads, because what they'll do when they do the line items of your purchase, right? They will put in there a credit for the value of your vehicle, right? So let's say they valued your vehicle at $35,000. So when you're going down the list of your purchase agreement, let's say the vehicle you bought is $50,000. They will show that $35,000 deducted from the $50,000, and that the $15,000 you have left over is the net balance, right? But then the line items keep going in the land and service contracts, gap contracts, anything else. And then you'll see balance owed on trade-in after that. And let's say the balance owed is $42,000. That actually gets added back in then to negate the $35,000 that they made it look like you had put down with your vehicle into the purchase price, and everything just shoots right back up. So it's very clever the way that they write this and make it look like that $35,000 is being put towards the purchase price, but lower at the bottom, they just add that $42,000 back in. So then you actually have that $7,000 worth of negative equity rolled back into it, and that whole $35,000 is washed away when they add it back in. But it's at the bottom. It's not always very discreet, and it can be hard for clients to see. So that's also something to be aware of, is to really look over these purchase agreements when you're entering into these finance contracts, because it's very easy to hide the negative equity. And like Courtney said, sometimes it just doesn't work out for our clients. Other clients, I've had it where they've said, you know what, I just want to be done with the car. I don't care. Just give me, as long as it's just a wash, if I owe a little bit of money, fine, but I just want to be done with it. I don't care. And it's a case by case basis, right? It all depends on what works for you. What we always tell clients is you'll never be forced into a buyback. You'll never be forced to accept something that you don't want. Because then on the alternative, right, we have some clients that don't want to get rid of the car. They really like it, or it's functioning, fine now. I think it's good as long as I still have my warranties. Just see what money you can get. It's a case-by-case basis that we navigate with you to help you understand your rights and remedies, what kind of cash you would get when it comes to evaluating whether to take a repurchase offer or to do the cash and keep. And all of that, comes into play when we're navigating these cases. There is also the option of a replacement. And a replacement is basically a swap out. But Stephen, I'll have you discuss how just because you're getting a swap out, it doesn't mean that you're free and clear of potentially owing any money, because you're not going to get a more expensive vehicle for free, right? I'll let you discuss how that works.
Sure. So with a replacement, what happens is what Emma said is called a collateral swap. That's where the VIN number is being changed on the loan that you already have. So you might be getting a new vehicle, but you still will have that loan for that vehicle. So you're not just getting a brand new free vehicle. In addition, if the vehicle that you select for a replacement has more features and upgrades than what you currently have, you will have to pay that difference. Usually you have to pay upfront when you get the new car, but sometimes they may be able to roll it into the loan. That's not very often, but you do not get free upgrades with a replacement. So clients sometimes are confused. Well, why would I have to pay more? Because the vehicle you selected for a replacement is not the same value as what you currently have. So the whole point of the law is to bring you back to where you would be if the vehicle was not defective, and not to improve the situation, but make it back to normal.
You're not going to get, a more expensive vehicle for free, right? You have to pay that difference. Again, and that's where cash and keep sometimes comes into play, because I've had it before where a client was offered a replacement, but it was like $20,000 to get into the vehicle because prices had increased so much since he had purchased his vehicle. Because we have seen a significant rise in the price of vehicles just across the board over the past couple years, and it just didn't make sense. So then we were kind of back to the drawing board with that one and had to reevaluate the different options that he had, which again just sort of brings us all back to the fact that having an attorney help you navigate this process is really important. Even if you don't have a lemon law claim and it's just simply breach of warranty and you're looking at a cash and keep, having an attorney tell you, hey, this is what your case is valued, is super beneficial. Because oftentimes, and Courtney, I'll let you quickly talk about this, customer care and the offers that they make are often just to placate, right? And just to kind of get you to go away and not bring a claim for a larger amount.
Yeah, I have a lot of clients who tell me that they were working directly with the manufacturer themselves through their customer care, customer retention team. And sometimes they're being offered a month or two's worth of payments back. Sometimes they're being offered nominal offers, and they're not negotiable. Whereas when we get offers, not only do they tend to be higher, but we can absolutely negotiate them. And that's not across the board, sometimes people are able to get wonderful offers. And if you call in and tell us that you've got such and such an offer from a manufacturer, there are lots of times where we're going to say to you, you know what, we likely can't do better than that. And that is a good offer and it's worth your while to take. So always give us a call if you have a question. We'd be happy to talk you through it, whether we end up signing you up or just give you a little bit of advice.
Right. You can call our intake line at 833-4CAR-LAW. All our consultations are free. You also have the BBB's website, or your state's attorney general's website has a lot of information related to lemon law specifically. When it comes to breach of warranty claims, that I would say there's not as much information available. So you definitely want to call in and talk to us about those types of situations. If you look at the lemon law and say, hey, it doesn't look like this applies to me, I wouldn't give up hope. I would definitely still call in to get some free legal advice because you may still have a claim against your vehicle manufacturer. And with that, we'd like to thank you for listening today, and we'll see you next time.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.